Good morning. Happy Tuesday. I've been pondering on talking about this issue for, I don't know, at least 2-3 days now. And I think in the interests of intellectual consistency, I kind of have to. I can't. One of the biggest reasons I got into doing what I'm doing is because there's so much misinformation out there. I watched a video by Audit the Auditors. Now you would expect that I would fall in love with it, and I had a huge problem with it the whole time. Huge problem being somewhat of an exaggeration. I had a small problem with it the whole time until I had a big problem with it. The small problem I had with it was, it was very well produced. Had all the visual things going on. I mean, it's not some jackass walking his dogs at dark 30. But it started off with right to travel. And right to travel, okay. Does a passenger have to ID? That's the pending question. Does a passenger have to ID? Right to travel has nothing to do with that. Absolutely fuck all to do with that. Are we talking about one state restricting the rights of citizens to travel to another state? Are we talking about one state's charging people from other states more money to do things, or keeping people from moving into their state or out of their state? No, then we're not talking about right to travel. Then he talks about the Commerce Clause and whether or not the federal government can preempt or occupy the entire field in anything related to commerce, the means or modality of commerce, i.e. roads. Can the federal government completely take the field and regulate roads? No, nothing to do with does a passenger have to ID. Finally, we get to a Ninth Circuit case, which should already ring alarm bells in your head that we're talking about one out of the 12 circuits. So we're talking about roughly, the Ninth Circuit's huge. So, I mean, we're talking about probably a quarter of the landmass-ish of the U.S., but it's still not, it's still not going to be throughout the U.S. And it's an appellate case, which means it hasn't gone to the Supreme Court. But in that appellate case, it said that, you have to have a minimum of reasonable suspicion. Okay, but what was that appellate case looking at? Well, that appellate case was looking at an Arizona state law. Something like 28-1595, something around there. I could be wrong, but it's basically if the driver gets stopped, driver has to identify, and then one of the subparts is if the officer suspects the passenger, reasonably suspects the passenger, or reasonably believes, or some language close to that the passenger has committed a crime, then the passenger has to ID, and failure to ID is I think it's a misdemeanor under that section. Something along those lines. It's just like if the driver fails to ID. So there is a statute in place that allows the officer to demand the ID if he has reasonable suspicion. Now, what about California? No, passenger doesn't have to ID. Passenger doesn't have to ID until technically he gets to booking. I mean, he's already been arrested and brought to jail, and then he's got to ID at booking. Now, you might want to ID earlier. It might save you time and trouble and money, but you might not. So legally, you don't have to. Texas, you don't have to ID until you're arrested if you're a passenger. Fuck it if the cop has reasonable suspicion. If he has reasonable suspicion, he could detain you and investigate, but you don't have to give up ID. So the answer to the question that is posed, that was pending, was maybe. Depends on the fucking state law. It depends on whether or not the officer has reasonable suspicion at a minimum, and then you've got to go from state law. But if the officer has reasonable suspicion you've committed a crime, in other states where there is a stop and identify style law that is based on reasonable suspicion, then it'll work there too. regardless of whether they're in the Ninth Circuit or not. Then it goes on to does the passenger have to submit to field sobriety tests? Well, to the best of my knowledge, nobody ever has to submit to field sobriety tests. There are implied consent laws, at least in Texas and California. Those are the only two places I've looked, but I'm sure there are other places where if you drive on the roads, then you agree, if you drive, you agree that if you're arrested for DUI or whatever your state's flavor of that is, you consent to one or more forms of chemical kinds of alcohol testing, breathalyzer, blood test, urine test, something. That doesn't apply to passengers. What would it take to get a passenger? Well, they wouldn't have to do a field sobriety test. You never have to do a field sobriety test as far as I'm aware. But in order for them to have to give a drug test, well, it would require probable cause. Probably a warrant too. Probably a warrant. Because they are not under the implied consent rules or under the implied consent laws of any state that I'm aware of. So the officer would have to have probable cause that them being drunk is somehow a crime, i.e. underage or maybe on probation where, if the officer suspects a person's on probation, then maybe the officer can arrest them, but who knows what all other kinds of Pandora's box laws are in play there. Anyway, my point is that Audit the Auditors, you went and fucked up. So please, for the love of God, if you're going to be giving legal advice, and Lord knows these auditors need legal advice, please fucking consult an attorney. Call a local attorney. If you don't believe me, call and talk to a local attorney. Get the answers you need from an actual attorney who understands the laws in your state. Thanks for watching. Have a great day.